Can you copy someone's vibe or style and be sued for it? Imagine dedicating years of your life to building your brand, only to find someone else is copying your videos, ideas, and style. This happened to one creator, and she is fighting back. Today, we're diving into the case of Alyssa Scheil and Sydney Gifford, a legal dispute that is shocking the entire creator economy. Alyssa, an influencer with over 430,000 followers, is being sued by Sydney Gifford for copyright infringement, misappropriation of likeness, and tortious interference with business relationships. But here's a twist. This case isn't just about two creators having beef with each other and the drama surrounding it. This lawsuit could set a precedent for how creators can go about copying other people's ideas. Make sure to stick around to the end because I will show a case study about one of my clients who's a big creator with over 1 million subs where this is happening to her, as well as the twist about the author of the Verge article that first covered all this. The author's name is Mia Sato, and I will link her article from Verge below because it's very important that we credit people, but especially more so for Mia Sato. Hi, I'm Tyler Chow, the creator's attorney. I have worked in Hollywood for the last 16 years at companies like Disney, Skydance, and BuzzFeed. And a year ago, I left Hollywood behind for what I believe is the new Hollywood, which is YouTube. Now I represent some of the biggest YouTubers in the world, where I function as their part-time general counsel and fractional CEO, where I help them with their operations and strategy, diversifying their revenue streams to 7 figures by launching products, like actual physical products, launching communities, and getting equity in brand deals, because I want to set creators up for a potential successful exit or acquisition in the future. I'm currently in the middle of negotiations with private equity funds to help one of my big YouTube clients sell his channel for 8 figures. What is my life's mission? To protect creators from getting screwed over by big companies and brands, and also by educating creators like yourself on how they can protect themselves. So let's talk about what is happening here between Alyssa and Sydney. Here's the backstory. Alyssa is an Amazon influencer renowned for her product hauls and clean aesthetics. Sydney, another influencer with a similar style, is suing Alyssa in Texas, alleging that Alyssa copied her content so closely that it damaged her business. Their fallout began in late 2022 after a brief interaction, which escalated when Sydney's followers noticed there was a striking similarity between their content after they met. Sydney claims that Alyssa's action led to a decline in her commissions and partnership, as well as views in her videos. To bolster her case, Sydney actually registered her posts with the US Copyright Office. This is a very uncommon but strategic move on her behalf, and very smart, because if you copyright your content, you have a better chance of being able to enforce violations, and you can actually attach federal violation fines that can really add up and be a deterrent to people who are trying to steal your content. So let's dissect the legal claims and evaluate each side's position. The first claim is copyright infringement, and Sydney needs to establish 2 key points. She needs to prove that her content is protectable under copyright law. And by the way, as an aside, every time we upload our videos to YouTube, it is automatically copyrighted. So in case you might not know that, you don't have to go and copyright every single one of your videos. In one of my last videos, I talked about how maybe you want to do that if it's a long piece of content like a film that might be, over an hour or 2 long. So going back to the first point, her content has to be protectable under copyright law. And this states that original expressions, not ideas, trends, or aesthetics, can be protected. Sydney must demonstrate that her specific content possesses sufficient originality. Number 2, Sydney has to prove that Alyssa's content is substantially similar to hers. Courts assess whether an ordinary observer, like a reasonable person, that's the reasonable person's standard, would perceive Alyssa's posts as copying, not merely drawing inspiration from Sydney's posts. The challenge here is that social media content often revolves around functional and derivative elements. Creators often engage with trends, templates, and shared concepts that don't typically qualify for copyright protection. Alyssa contends that her videos are influenced by Amazon's product promotions and not by Sydney's content. So for those of you who don't know and are not part of Amazon's affiliate program, Amazon will often release a list of products that they want their creators to promote. So what Alyssa is saying is, I just chose off of the same list that Sydney has access to, and I just so happened to choose the exact same items that she did. But I can show some photos here of how similar these products are, and actually how the layouts of the photos are very, very similar. Realize that historically, courts have required near identical copying for a finding of infringement. Unless Sydney can pinpoint specific unique features that Alyssa replicated, this claim is going to be hard to prove. The next claim involves misappropriation of likeness, also known as the right of publicity. Sydney accuses Alyssa of emulating her hair, her makeup, her overall style, just to unjustly profit from that persona. There's also a very interesting tattoo that seems very similar similar. At some point, their hair looked the same, the color was the same. I'll show photos here so you can see how similar they are. This is a bold assertion. To prevail, Sydney must prove 2 points. 1, Alyssa intentionally imitated her persona, and 2, this imitation caused consumer confusion or financial harm. However, courts rarely recognize aesthetics like hair or makeup as protectable, especially when they are part of a widespread trend. The clean girl look is prevalent across all the platforms. It's not an innovation unique to Sydney. Remember, Hailey Bieber was sort of the first pioneer of this look. A comparable case, however, is Kim Kardashian versus Old Navy. Remember, Old Navy hired a model that looked very close to Kim Kardashian to promote their clothing. Kim actually succeeded in that lawsuit because the resemblance was deliberately used by Old Navy for commercial gain. Sydney will face challenges in proving intentionality in this context. She could prove, well, we met, and so Alyssa saw how successful my content was and she decided to copy my look. Let's move on to the next claim, tortious interference with business relationships. Sydney is claiming with this final claim that Alyssa disrupted her brand relationships, her partnerships with them, leading to a decline in her income. To succeed, Sydney must demonstrate 3 points. 1, that she had valid relationships with brands. 2, Alyssa intentionally interfered with them. And 3, this interference caused measurable financial harm. This is complicated because Alyssa holds the position that any content overlap is just coincidence and influenced by, again, Amazon's promotional materials, not a deliberate attempt to undermine Sydney. Proving that Alyssa's actions directly cause financial harm as opposed to other market factors or the actions of other creators poses a significant challenge. This claim will hinge on evidence. If Sydney possesses communications or contracts indicating that brands specifically shifted from her to Alyssa due to copying, it would strengthen her case. Absent such evidence, the claim faces an uphill battle. I want to point out this proving of damages. In my last video about whether or not Mr. Beast would sue Dogpack, remember, he had brands that specifically said that they stopped their campaigns with Mr. Beast because of the Dogpack videos. So there, Jimmy can show damages. But here, Sydney has to show that brands say, hey, by the way, we stopped working with you because there's the other creator who looks exactly like you and we're giving her your brand deals instead. I'm not sure that she has evidence of that. Adding a weird twist to this lawsuit. So remember I said above, the Verge published an article detailing the case between Sydney and Alyssa. And the author's name is Mia Sato. She was the first journalist to cover the story. And so basically, you know, in the journalism world, it meant that she scooped this story. Subsequently, the New York Times published a remarkably similar piece just a week later. And Mia is claiming that the New York Times sort of copied her story without giving her credit. I think that was the biggest issue, is that they didn't give her credit. And several other publications also took her article as a basis and ran their own stories. This situation underscores the challenges that journalists face in protecting their own work. While facts themselves aren't subject to copyright, the unique expressions and structure of an article are. I think Mia is saying that a lot of the quotes that she used was also used in these other articles. If a publication replicates the distinctive elements of another person's work without permission, it may constitute copyright infringement. However, proving such claims is complicated. The plaintiff must show that the alleged infringer had access to the original work, which is not hard to prove here, and that the two pieces are substantially similar in their expression, not just in the facts that they present. The scenario mirrors the issues that creators face, the fine line between drawing inspiration and outright copying. It highlights the importance of respecting someone else's intellectual property rights across all creative fields, including journalism. And I wanted to share a case study with one of my new clients that just came to me. They're a big hack channel. They're over 1 million on YouTube and across all platforms. And although they came to me because they wanted to copyright their channel name and their business name, they came back to me with this issue of another channel closely copying their content and the way it's presented. Apparently there's this other channel who wears the exact same clothing as my client. The colors, the hair looks the same, and it's causing confusion for their audience because I think what's happening is my client had the older, more established channel, and people are watching this other person's channel thinking that it's my client's channel. This is going to be an ongoing case, and I'm advising them right now as to what to do. We might be sending a cease and desist letter. So follow along. Make sure to sign up for my newsletter, and I'll be announcing the sale on my templates in my community later on in the video. So what can creators learn from this case. And by the way, it's still ongoing, but it hasn't been dismissed, which is very interesting. The judge has agreed to let this case go forward. So what are the 3 critical takeaways for creators? Number 1, document your creative process. Maintain detailed records of your content creation, including drafts, outlines, and behind the scenes footage. This documentation can be invaluable if you need to prove the originality of your work. Number 2, protect your unique content. Register your original standout work with the US Copyright Office. While this won't protect every piece of content, it does provide legal leverage if someone copies specific materials. And remember, because you have a copyright, it is a federal violation, and we can attach federal fines to it that can really add up against the violator. Number 3, understand the line between trends and theft. Engaging with trends is common in the creator space, but there's a fine line between inspiration and imitation. Ensure that your content adds unique value and doesn't replicate another creator's distinctive elements. So these lessons really teach that it is not okay to copy someone else's exact ideas, exact presentation, right? If you can show that your videos or your photos are being taken shot for shot, like where the angles and the products are very, very similar, almost identical, you will potentially face some other creator calling you out and potentially suing you, like we are seeing Sydney suing Alyssa. What are your thoughts? Do you feel like these claims are valid? Have you ever been a victim of people stealing your content? Let me know in the comments. And also, I am happy to say that I am finally launching my templates after so many requests from those of you in the audience. Thank you for being so patient. I'm actually launching a holiday sale right now. If you buy my template in the next 2 weeks or 1 week, depending on when this video releases, before the end of the year, I will be adding in a free live Q&A with me where you can come ask me questions about the independent contractor template, about your channel, about copyright strikes, about if you are a victim of IP theft. You can ask me about trademarks, setting up your LLC, whether or not you need general liability insurance or media insurance. The answer is usually yes for the first, and the media insurance, especially if you're doing reaction or review videos. Remember, CoffeeZilla is being sued by Logan Paul right now, and because he doesn't have defamation coverage in his media insurance because his broker really failed him, he has to pay all of his legal fees against Logan Paul out of pocket, and it will be probably in the 7 figures because litigation is very expensive. I say this to all creators. You need to have your IP protected by agreements. If you're hiring editors, producers, managers, assistants who could be creating any sort of IP for you, you need an independent contractor agreement or an employee agreement that states that all the results and proceeds that the people who are working for you are making is owned by you. Because you don't want the situation where somebody turns around and says, you know what, I own this content, I own your channel because I made you or I edited all of your videos. I'm Tyler Chow, the creator's attorney. Remember, you need to protect your work because your IP is your future. I'm currently putting YouTube channels into trust for 2 of my clients. Realize that a YouTube channel with 50, 100,000 or 1 million subscribers is more valuable than real estate. And being able to leave that for your kids, this is the American dream. You no longer have to wait for a studio head to deem your story worthy of being told. You can turn on the camera if you're brave enough to film, tell your story, and millions of people could potentially see it. I love this so much. I love protecting creators. Thank you for always showing up and being patient with me as I grew my law firm this year. I am speaking in Dubai in a few weeks at the 1 billion follower summit. I just got announced at South by Southwest, so maybe I'll see some of you there. And I was just invited to speak at MIT, which is such a dream come true, at their AI summit. And the summit wants to hear about my thoughts on AI and its impact on creators and creatives. I'll see you guys next time. Make sure to drop in the comments what other videos or legal dilemmas that you are facing as creators, and I'll make sure to cover in the next video. Okay, bye.